Before I jump into the balance of my presentation and our opening statement, I wanted to go back to the timeline that I believe was one of the questions from Professor Leafley. And with respect to the reservation and what one would have expected, in other words, what could the sovereign have done? What they could have done was what they did on the 11th of June of 2018. And on the 11th of June, there's a reservation that reads as follows in Spanish. Las partes no han llegado.
The parties have not reached any agreement to submit to arbitration, nor under UNCITRAL rules or any other type of arbitration.
Is not set forth in the sovereign's letter of 24 May, and it's not set forth in the sovereign's letter of 18 May. There is a reservation in both of those letters, not with the detail as set forth on the 11th of June. And what exactly are they reserving? They can't possibly be reserving matters that they agree to in that correspondence. By way of example, in the letter of 18 May 2018, identified for purposes of this arbitration as C-132, in that letter, the Dominican Republic agrees that the UNCITRAL rules shall apply. And I'll read in Spanish on page 2 of C-132. Adicionalmente,
additionally, we take advantage of this to clarify that in this procedure, to which the UNCITRAL regulations would eventually apply, the regulations of 1976, and they continue to say, we do not believe an answer is deemed necessary to the arbitration notification.
Now, they do make a reservation of certain jurisdictional defenses, which clearly, in our mind's eye, could not include a jurisdictional objection that relates to Article 1, a lack of consent, but could include jurisdictional defenses such as indirect investors, which is a jurisdictional defense that they're positing now. The subsequent letter, 24 May 2018, which also does not have the express reservation that's set forth in the email from La Doctora Contreras of 11 June 2018, obviously can't reserve actions that are presently being taken in that correspondence. And what do they do in that correspondence? They designate Professor Cohen, thus establishing that it's not going to be a sole arbitrator, which is one of the alternatives that's set forth in paragraph 2, but rather a tribunal.
Do you have a reference also for that letter, please?
I do not, but I can provide it. And if not, I can provide the tribunal with a copy. I don't know if that correspondence is in evidence. It is correspondence exchange between the parties, and with the approval of the tribunal, I'm happy to make it approved.
We have copies of that, but that's fine. I just wondered if it also had a reference for an exhibit number. Okay.
It does not.
Thanks.
Mr. Chairman, would you like us to identify it with an exhibit number?
You can do it later.
Absolutely. Thank you, sir. We will do that. Turning now to the respondents, what we consider failed interpretation of the treaty. What is it that the respondent is arguing? And again, we touched on it a little earlier, and of course we heard in the opening presentation of our colleagues their position with respect to Article 1, Article 2, and their lack of focus on Article 3. And of course, I also note that in their mind's eye, the comma is of little consequence and of no import. But what they argue, and I'll jump to Spanish, no deja lugar,
does not leave any doubts that it's necessary to have a separate agreement in writing by the state and the investor to submit the dispute to a tribunal under UNCITRAL.
It does not provide any consent, and as a result of that, ex post agreement is required. What does that mean? What that means is that the sovereign, as I articulated earlier, can always block the initiation of the arbitration. Notwithstanding the word shall, notwithstanding what was agreed in our mind clearly in paragraph 1, under their reading, even if the investor accepts the proposal, the offer to prosecute one of those three options, it's of no moment. Because one of those two options, I would assume, international arbitration, requires that the sovereign, after that action is taken, agree again, in writing. There are, of course, examples of treaties where you have ex post consent. And I'm sure the tribunal is intimately aware with the language in those laws and in those treaties. And I identify in the next several slides examples. Here's an example from the 1979 Sweden-Malaysia Treaty. And as the tribunal can tell, just on the face of the document, they're vastly different than the language that is set forth in paragraph 1 and paragraph 2 of Article 13. In the Sweden-Malaysia, it shall upon the agreement by both parties to the dispute. By both parties to the dispute. If we look at the Tanzanian Investment Act of 1997, the dispute may be submitted to arbitration as may be mutually agreed by the parties. May, permissive. Shall, mandatory. Another example from the Uzbekistan law of guarantees. The parties involved in investment disputes can, not shall, not may, can, on mutual agreement, determine the authority settling such disputes. Very, very different than the language that we see in the treaty in dispute here. And where do they ultimately conclude? What does this analysis of the sovereign here ultimately lead them in their analysis of these provisions? Well, what they say, and here is a paragraph 9 in one of their submissions, the submissions of 21 October 2019, they argue with respect to paragraph 1, jumping to Spanish, that it's meramente.
It's merely to identify potential alternative for the settlement of disputes.
And then they go on to talk about the word shall. And we've seen a number of cases that have looked at the word shall in arbitration provision and treaty provisions similar to ours, where the tribunals have time and again said shall means shall, and it's mandatory. But the Dominican Republic here continues to insist, to hope beyond hope, that shall means something less. That shall, jumping into Spanish, no se trata.
It's not a magical word.
And they say, well, don't take our word for it. Look at Black's Law Dictionary. And Black's Law Dictionary, in its laundry list of definitions for the word shall, actually says, in certain instances, shall can mean may. And they say, jumping into Spanish, definición de shall.
The definition of shall, amongst which we include the existence of an obligation as well as a possibility, should or may, or something that would happen in the future.
This morning. They say Black's Law Dictionary supports our argument. So don't look at the other cases that have defined shall just like Michael Leachin. Look at Black's. So we did. We looked at Black's. And what does Black say? Well, definition number 1 says shall has a duty to, more broadly is required to. This is the mandatory sense that drafters typically intend and that courts typically uphold. So definition number one, shall is what we say shall means, and what multiple tribunals have time and again interpreted shall to mean. Well, what else does it say? Well, it says only sense number one, that it's a duty, that it's required, that it's mandatory, is acceptable under strict standards of drafting. Well, when you're drafting a treaty, I would imagine you're dotting your I's and you're crossing your T's. You're not just doing it on a lark. No, you're strictly drafting it and making sure that words mean what they mean. And then we get to the definition that they rely upon in their footnote. May. It's not definition 1. It's not even definition 2. It's definition 3. And when, pursuant to Black's Law Dictionary, does shall mean may? When a negative word such as not or no precedes shall. Now, in this treaty, I've looked at it. Shall, in paragraph 1, is not preceded by not or no. So pursuant to Black's Law Dictionary, shall cannot mean may. Period. Full stop. And to not make that clear in the footnote to support their position is disconcerting and unfortunate. So we contend that shall means shall, and that their effort to try to change the meaning, the ordinary sense of the word, based on a manipulated definition, doesn't lead them to victory. Metal Tech. What do they argue with respect to this case? Jumping into Spanish.
Preliminary, we have to remember that in international law, there is such a thing as consent to international arbitration in abstract.
Provision in this treaty, Article 1, Article 2, Article 3, makes reference to rules. It makes reference to the UNCITRA rules, specifically. So it's different, I say. It's not in the abstract. And I understand that they have a different interpretation, and that's fair. But to say that these provisions are devoid of any reference to rules ignores the text of the treaty itself. And what's the argument here? The respondent has expressed its consent to ICSID arbitration in Article 8.1 of the BIT. Respondent submits that it consented to arbitrate only those disputes concerning lawfully implemented investments. So even in this case, looking at Article 8, which is similar, 8.1, similar to our paragraph 1, it recognizes that they consented to arbitrate lawful investment disputes. Now, do they focus on that language, the respondent, in the Metal Tech case? No. They focus on Article 10 of the Law of Guarantees. This is the section that they cite in this opinion. And they claim that the claimant contends that the tribunal has jurisdiction to entertain claimant's Uzbek law claims. Now, ultimately, what happens? Article 10 of that law, not the BIT, where unequivocally established that pursuant to the BIT, lawful claims are subject to arbitration. There is consent. They say, given that that law does not make specific reference to anything, well then, there's no jurisdiction. But of course, that's not the case here, because our provision makes specific reference to UNCITRAL, unlike in Metal Tech. We come back to the idea that serán has various meanings. And I come back to serán, shall, frequently, not because I'm in love with the word, but because they rely on it significantly. They rely on this idea that shall means something different than mandatory. For their position to prevail, we posit that this tribunal must accept that shall means may. And that would be, in our mind's eye, outlandish. Well, let's see what Planet Mining does with the word shall. And in the respondent's opening, they looked at the arbitration provision. in Planet Mining. It was on the screen for a while. And you see the distinction between may, submit, and on the bottom in 4A, you see shall. And clearly, this is a different provision, not identical to the one in dispute here. But the tribunal here wrestles with the word shall. And Indonesia, the sovereign, contends that the wording shall, consent in writing within 45 days, contained in Article 11.4, shows that a subsequent act is required to achieve consent and that Indonesia legitimately withheld its consent. A similar argument that's being made here by the Dominican Republic. What does the tribunal ultimately conclude? The tribunal concludes, like other tribunals that we've already seen, that the use of the word shall without a stated exception leaves no doubt that Indonesia was obligated to grant its consent. So in this issue of shall and what does it mean, this case, Planet Mining, the tribunal analyzes the very issue that they're asking this tribunal to analyze. What meaning should we give to the word shall in paragraph 1 of Article 13? And Planet Mining said, hey, shall means shall. They've consented. We go back to their theory that the position of the Republic is that it just provides alternatives. That is their position with respect to paragraph 1. Options. It's a laundry list that in reality makes no sense, because the only way to rationally read Article 1 pursuant to the respondent leads you to the ridiculous conclusion that the investor is compelled to bring 3 claims simultaneously, one in international arbitration, one in local arbitration, and one in local courts. That can't be the case. Respondent's interpretation renders meaningless paragraph 1, means nothing. It's belied by its own authorities, authorities that have been relied upon for other purposes by the respondent. And we should never lose sight of the fact that the dispute resolution provisions in the treaty, Article 13, makes reference to rules, uncitral. And why would it do that? They could always agree to particular sets of rules. So it begs the question, where can the investor seek redress if ex post consent is always required? Where do they go? Under the respondent's theory, the dispute resolution provisions, in point of fact, are in truth meaningless, because the claimant, the investor, exercising their rights under paragraph 1, needs to go, according to their theory, hat in hand to the sovereign and say, please, would you please agree to any one of these 3 so that I can try to seek vindication? And if you don't agree, well, then you know what? I don't have anywhere to go. And that simply can't be a reasonable, fair interpretation of the language of this treaty. Respondent's interpretation with respect to paragraph 2.
Sorry, Mr. Renzo.
Yes,
I have a question about these options in stress testing that argument. Is consent, maybe I can ask this another way, is your understanding of respondent's argument, where they do not concede that any consent has been given in paragraph 1, that would preclude a claim before the national courts of the Dominican Republic?
Professor Lee, I don't know. I don't know what their position would be. I'd be interested to hear from them, what redress we have if Article 1 does not provide consent. My understanding of their reading of Article 1 is it doesn't provide consent, I assume, to anything. So I don't know if we initiated a domestic arbitration if I had to go hat in hand and ask for their consent. Because as I understand it, they say Article 1 is nothing more than a laundry list that provides consent to nothing.
And I'm not referring to national arbitration, I'm actually meaning to the courts, because the courts are one of the three options listed in paragraph 1. And so would it not, by operation of law, be that that option is always available?
One would hope. But I don't know what their position is with respect to that. I don't believe that they've articulated a view on that in any of their submissions.
Sorry, but may I ask you what the claimant's views are on this? So is it possible, according to the Dominican Republic law, to bring the case before domestic courts?
Professor Cohen, I'm not a Dominican law expert. Again, as I noted in my response to Professor Leithley, I have to assume that if international arbitration is blocked under their theory of further consent, I assume there has to be a place where I can seek redress. Perhaps the only place I can go is in the Dominican Republic courts. And maybe when I file my action in the Dominican court, which of course would make no sense for a Jamaican investor, to, in my mind's eye, to feel protected in bringing an action against a sovereign in a domestic court. I don't know what the sovereign's reaction is going to be if I bring that claim. Perhaps they'll move to compel national arbitration. I don't know. All I know is that it hasn't been stressed or addressed with any degree of specificity in any of the respondents' positions. So I don't know where that would leave us. But I have to assume that we could endeavor to bring a claim in a domestic court.
Yes, I just don't know, and I'm assuming maybe if I understand respondents' argument, that there would be sovereign immunity, perhaps.
That's exactly right.
That then it might not automatically be. Therefore, you could put domestic litigation in the same box as national and international arbitration as something that would require consent.
Professor, I agree. And my understanding of the argument, quite honestly, the way they look at paragraph 1 is that it means nothing. It's just a laundry list of options, and that consent is required because paragraph 1 provides consent to nothing under my understanding of their theory. And I don't believe under their theory it's limited exclusively to the issue of international arbitration. Turning now to paragraph 2, and jumping into Spanish, and we go back to the second layer of consent. Sin ese acuerdo.
Without that later consent, as the dispute arises, there is no consent by the state to national arbitration in accordance with the terms of Article 13 of the treaty.
Argument. We want to look at 4 subsets of issues. And the first is the Vienna Convention, which of course was addressed by our colleagues, counsel for the respondent. And we all know, of course, the Vienna Convention, and we're all familiar with Article 31, General Rule of Interpretation. A treaty shall be interpreted in good faith. Is it good faith to say shall means may? In accordance with the ordinary meaning to be given to the terms of the treaty. Is the ordinary meaning of shall may? In the context and the light of its object and purpose. One of the objects and purposes of this act, of this treaty, of Article 13 in particular, is to provide a viable forum for a foreign investor to vindicate or attempt to vindicate their rights. If the only vehicle, place where vindication could happen is in a domestic court, maybe if there is no sovereign immunity defense, and arbitration, international arbitration in particular, requires an additional layer of consent from the sovereign. Is that reading of Article 13, paragraph 1, paragraph 2, and paragraph 3, is it reasonable? Is that consistent with the object and purpose of Article 13? We posit no. And is it reasonable? Is it good faith to say that the words o, or, in paragraph 1 should really mean and or e? Is it really good faith to say that we don't really need to look at the comma? The comma is inconsequential, I believe is the language that they use. The comma is inconsequential. And Article 3, I apologize, paragraph 3, even though it speaks to the issue of who accepts the offer, the investor? Well, given that that's really a state-to-state issue, and even though it's in the same Article 13, it really adds nothing to the tribunal's effort to try to interpret the balance of the provisions. So again, we go back to shall. We contend that it is not the ordinary meaning to say that shall means may. It's not the ordinary meaning to ignore the first part of paragraph 2 that begins where the dispute is referred to international arbitration. And it is not ordinary meaning using the words posited by the respondent with respect to the comma that it's totally inconsequential. Mind you, this is not the English text. This is the Spanish language text. And words have meaning. Commas have meaning. They choose to ignore them. In their context, respondent's interpretation ignores the concept of paragraph 1 and renders it meaningless. That's what they argue. Respondent's interpretation positions in conflict paragraph 1 and paragraph 2. And they say paragraph 2 trumps paragraph 1. They ignore, as I noted earlier, the impact of paragraph 3. And in our mind, their interpretation destroys Article 13's effect utile with respect to international arbitration, because it gives the key to that dispute resolution forum exclusively to the sovereign. And what was the object and purpose of the treaty? To promote greater economic cooperation, recognize the needs to stimulate and protect investments, to strengthen economic ties. And when this treaty was being considered by the Dominican legislature, well, what did the Senate say? Well, they said, listen, the treaty is necessary because we need a legal, judicial framework to promote and protect investments. And mind you, this is reciprocal. The Dominican Republic wanted to protect its investors that were going to Jamaica, going to CARICOM, no differently than CARICOM wanted to protect its investors that were going to the Dominican Republic. I'm confident. Yes, sir.
Mr. Lorenzo, in your view, the word judicial includes arbitration?
It does, yes.
Judicial?
Yes.
Thanks.
What was that framework? The framework is set forth in Article 13. And the framework contemplates court, domestic arbitration, international arbitration. And going back to the veto issue, it's just unreasonable, not consistent with treaty interpretation, to read Article 13 and find that a second layer of consent is required. We contend, Mr. Chairman, members of the tribunal, that the reading that is mandated by the respondent is not a good faith reading. It's not a fair reading. And it requires that the provision be modified extensively, and it requires that other provisions in Article 13 be ignored. The preparatory works. And of course, under Article 32, they can be considered. And we've asked for these. Obviously, Mr. Lee Chin can't knock on the door of the Dominican Republic and say, I would like all the preparatory works, please, of the CARICOM Treaty. So we needed to ask the sovereign. And one would have to assume that the sovereign, with respect to treaties, international treaties, maintains somewhere the preparatory works associated with those treaties. So that if a dispute sometime down the road would manifest itself, they would have the institutional documentation and background to help explain them, if necessary. We asked for that. And the response was, well, they were lost in a fire. Maybe, because there was no evidence. They just knew that there was a fire in a place where the documents could have been held. So then on the 18th of October, we understand that they find documents at the Banco Central. And what's interesting, notwithstanding their representations that they made a diligent search, they actually reach out to El Banco Central on the 11th of September. The responsive documents were due on the 3rd of September. So their diligent search that led them to a fire of an area where maybe the documents were held, apparently there was an epiphany after the due date of the production that caused them to reach out to El Banco Central. Well, and luckily, I guess, the Banco Central found something. And they put a lot of weight on this preparatory work. Even though they say that the treaty is clear on its face, you don't have to look at anything. I don't need a witness. I don't need an expert. I don't need anybody. Just read it. They put a lot of weight now on this preparatory work. This is, the Holy Grail. And we should rely upon it, and we should really look at it, and we should consider it biblical truth. Even though the iterations of this clause, there were 19 rounds of negotiations. 19. They found preparatory works for 7 rounds. The balance of the rounds, which could touch on this provision, we'll never know, were burned, lost, or somehow misplaced. But we'll look at them nonetheless. The handful of documents that they managed to discover established that when the first draft of the treaty was circulated, the Dominican Republic was not even contemplating investor disputes. It was state to state, as you can see in slide 110. And over time, very quickly in fact, CARICOM proposed investor-state dispute resolution provisions. And it's Article 11 that you see on the screen on page 111. And we believe this provision contains, in paragraph 1, a binding offer of consent. And then it goes on in paragraph 2 to refer to the options that were available in this preliminary draft. And this was reviewed also by my colleague, La Doctora Frutos Peterson. And of course, over time, what happened with this provision? Well, it not only contemplated UNCITRAL, but it also contemplated ICSID. But as the final draft of the treaty ultimately bore itself out, ICSID was dropped, and the word either was eliminated. And we were left with the provision that we have today, which is strikingly similar, once ICSID is dropped, to the provision that was set forth in Article 11 of the preparatory works. Now again, the respondent's interpretation ignores the deliberate choice in Article 1 of international arbitration, and that the dispute shall be resolved there. It ignores, of course, where the dispute is referred to arbitration. That language remained. And of course, it ignores the party's deliberate choice to leave the UNCITRAL rules as a default option, as set forth in draft Article 11 and ultimately included in Article 13. Now, our interpretation of Article 2, we believe, is the most appropriate. But given that there's a debate as to how that provision should be interpreted, we sought out the individuals that led that negotiation. Ambassador Hilton and the Dominican ambassador, Ambassador Zade. And we met with them independently, and we ultimately obtained the declaration from both. One which was stricken at the request, incredibly, of the Dominican Republic. The Dominican Republic doesn't want this tribunal to know or to hear what their own ambassador believes to be true. Mind-blowing. But it doesn't matter. We have the testimony of Mr. Hilton, of Ambassador Hilton. He will be here. His credibility can be tested on cross-examination. They may want to discount it. They may want to say that it's the recollection of a tired old man. But what I can tell you about the ambassador is that he recalls. And what I can tell you about his testimony is that it's unrebutted. It is unrebutted. They had the opportunity in a litany of submissions to find one person in the Dominican Republic, one human being that participated in that negotiation, who lived it, who understood how these treaties were managed over time, to say that interpretation of Ambassador Hilton is wrong. The interpretation of Ambassador Zaide is wrong. The claimant's position with respect to consent is wrong. There isn't a single representative, witness here that challenges the statements that are made by this ambassador, that challenges the statements that were made by Ambassador Zaide. Regrettably, he's not here, and we all know the reasons why. But again, they don't want to hear from him. They don't want this tribunal to consider him. But irrespective of that, the testimony that is here is unrebutted, because there isn't anyone from the Dominican Republic who has been willing to come to this tribunal and say that the argument that's being posited by its lawyers is accurate. In addition to the other points that we've already identified, the respondent's interpretation of paragraph 2 is at odds with relevant arbitration jurisprudence.
Sorry,
Yes,
Mr.
sir.
Lorenzo. I think you're soon going to move off the text, and I'm kind of held up on the text still. And I have one more question,
Sure.
if I may. You've already answered my question about the y la parte language.
Yes, sir.
I'm trying to now explore the redundancies that could exist either way. And one potential redundancy that I'm worried about, or that I'm thinking about, is the podrán acordar, which for me has two challenges for claimant's position. One is the plural, and the other is the verb. And the plural invites that both be involved in the verb, to agree. And so I wondered what, I've seen this in your papers, but I wondered if you could just address that briefly.
Sure. And could I approach that screen just so I can? Great.
Please.
And I think you're referencing, Professor Leafley, the podrán acordar, correct?
Exactly. So that's line 2 of paragraph 2.
Line 2 of paragraph 2. And you're saying, well, this is more than one,
Yeah.
correct? And well, how do I reconcile that?
Well,
What do they have to agree to?
That's right. It's giving, arguably, both parties a role to agree.
Correct. May agree to un árbitro internacional, one arbitrator, or a tribunal. We contend that, factually, the parties agreed that this arbitration would proceed por un tribunal arbitral, through the correspondence, etc. If the parties are unable to agree to this, there's a comma here. Okay? There's a comma here. What flows? Well, then, there's a special agreement. They could theoretically agree to a special agreement. And if the parties do not agree to a special agreement, well, then the arbitration proceeds as established under the rules of UNCITRAL, which include a rule that specifically addresses how arbitrators are selected.
And doesn't the podrán acordar also apply to the UNCITRAL rules?
No.
Why not?
Number one, because of the comma.
But podrán acordar refers, I would say, at the first level to either a sole arbitrator.
Correct.
I was referring to it as an institutional. Perhaps that's a mistaken interpretation. I think a better reading is a sole arbitrator as against a tribunal, an ad hoc tribunal. But isn't that what they have to agree on? And then you.
On what? I apologize. I missed it, Professor Lee.
So the podrán acordar is they may agree to either one or three. And your case, I know, is, as a matter of fact, 3 was agreed to. That's your position.
That's one of my positions, yes.
Right.
My other position is, even if the parties did not agree to 1 or 3, then the parties could agree to a special arrangement. If the parties do not agree to a special arrangement, which in this instance they did not, then the arbitration shall proceed under the the UNCITRAL rules, which are the default rules. And those default rules provide for, if the parties cannot agree on 1 or 3, whether or not it's 1 or 3. Because the UNCITRAL rules, I believe it's Article 25, Article 5, the manner in which the number of arbitrators is determined.
And what would that default be? I should know the answer to this under the UNCITRAL rules, but where would that? Will we default to 1 or 3?
I think it's 3.
It's 3 arbitrators. It's Article 5.
Yeah, no default.
Article 5, if the parties have not previously agreed on the number of arbitrators, and if within 15 days after receiving responded the notice of arbitration, the parties have not agreed that there shall be only 1 arbitrator, 3 arbitrators shall be appointed. Sorry.
Thank you very much.
Thank you, sir. Yes, sir. I'm sorry.
Yeah, Mr. Lorenzo, just to understand you well, so your first step is the investor and the party concerned may agree to 1 arbitrator or tribunal. And consequently, if they may agree, they can also disagree.
They could disagree.
Yes. So then, if there is disagreement, then the rest of paragraph 2 comes into play. That's it.
Yeah. If there is a disagreement,
So, but if there is a disagreement, then there is a possibility of a further agreement. Is
Well-
that your point?
no, sir. Yes and no. I'll try to. I'll try to clarify. I do what I can. If there is a disagreement,
You can say also maybe. Yes,
yes, no, or maybe. I'll put them all on the table.
Respondent will be selectively extracting part of that answer.
No, there'll be an ellipses there. If they're unable to agree on 1 or 3, which again, factually, I don't believe to be the case here, then the parties can attempt to agree on a special agreement to resolve the issue of appointment of the tribunal. Special agreement, tribunal to be appointed by a special agreement. Okay? If there is no special agreement, because the respondent doesn't want to agree on a methodology to appoint the tribunal, then the default are the UNCITRAL rules. And the UNCITRAL rules, pursuant to the rules themselves, have a rule that addresses the manner in which the tribunal is to be conformed. 1, 3, etc. I apologize for turning my back, Professor Cohen. Okay? Did I answer the question? You may not. You're not convinced. I hear you.
Because your point is they can agree about having 1 arbitrator or a tribunal.
Correct.
But if they disagree, then there will be a tribunal.
No, sir. No.
Because the special agreement would be about what? You said to constitute the
How to
special...
appoint them.
how to appoint
And
what?
that's the language that it says. If you look at the language,
The
the language says, may agree to refer the dispute to an international arbitrator, 1, or ad hoc arbitration tribunal,
Yes.
3, 5, 15, whatever the case may be, to be appointed by special agreement. So if the parties are unable to agree on 1 or 3 and are unable to agree on a special agreement to determine how to appoint 1 or 3, then it defaults to the uncitral rules. And the uncitral rules, in the rules themselves, determine how to appoint the tribunal. So the nuts and bolts of the arbitration, in other words, how do I appoint the tribunal, is either mutually agreed by the parties. And in the absence of mutual agreement, it's not that they walk away from their consent and they get a free pass. No, then it defaults to the uncitral rules. Thank you, sir. Going back to the relevant arbitral jurisprudence, and we come back to Garanti. And what we see here on the screen is a provision which is very similar to ours. Article 1 of the Turkmenistan BIT shall be submitted to international arbitration. Very similar to the language in our treaty. Shall be submitted to international arbitration. One of options. The tribunal there took it upon itself. We look first at whether Turkmenistan has consented to participate in international arbitration at all. That's the exact question that's being posited by the sovereign here. Through paragraph 1, have they consented? What was the tribunal's decision? Article 8.1, language similar to ours, shall. Article 8.1 establish unequivocally Turkmenistan's consent. Turkmenistan has consented to arbitrate disputes with UK investors, period. So they have found the consent. And then they also look at 8.2, because 8.2 has language similar to paragraph 2 in our treaty. And they title this section, what kind of arbitration? What are the nuts and bolts of the arbitration? Not the consent issue. And what does the tribunal there opine? Hold. The tribunal holds, we find in Article 2, only a menu of options concerning the arbitration process and a default selection, as we contend exists in our paragraph 2 of our treaty. Consent, as explained in the preceding section, 8.1, our paragraph 1, is granted in Article 8.1 of the UK Turkmenistan BIT. And then it looks at where the dispute is referred to international arbitration. The same phrase in our treaty, indicating that 8.2 only comes into play after the determination has been made under the provisions of 8.1 to refer the dispute to arbitration. This tribunal analyzed similar provisions, found consent in the language of Article 1, and found that what was 8.2, our paragraph 2, focused on. It was what kind of arbitration? A menu of options concerning the arbitration process, flexibility to give the parties the opportunity to attempt to agree on a laundry list of things, a few things, and if not, then it defaults to uncitral. Under no set of circumstances was it envisioned that in that laundry list menu of options, they could hold the consent to arbitration in paragraph 1 hostage. And what do they say with respect to this decision? Well, clearly the respondents don't agree with it. What they say is it's wrong and it's isolated. It's there, but they have the opportunity, of course, to disagree with it. And what they say is, ignore the majority opinion. Focus on the dissent. And the dissent was authored by a well-regarded, of course, arbitrator appointed by Curtis. But even if you look at the dissent even says that without mutual agreement between the claimant and the respondent in the nuts and bolts of the arbitration set forth in Article 8.2, only unsatral ad hoc arbitration is available. Why? Because that's what it says. That's the default. No different than the provision in our case. Which leads me to the interpretation of Article 2 that is being posited by the respondent. And what they are asking this tribunal to do is ignore the unequivocal consent in paragraph 1. Ignore the word shall. Ignore o in paragraph 1. Ignore paragraph 3. Ignore the language in paragraph 3. And with respect to paragraph 2, modify it. And everything that's set forth in paragraph 2 requires their unequivocal subsequent consent. And if they don't provide it, then there is no consent. If they don't agree, there is no international arbitration. The keys to that kingdom lie exclusively in the Dominican Republic. Period. Full stop. And we believe that that interpretation is wrong, and we believe that that interpretation is inconsistent with a good faith reading of Article 13, inconsistent with the Vienna Convention. Consent via the MFN clause. This is an issue that I know was touched on by my colleague, La Doctora Alvarez. Obviously, we believe that there is unequivocal consent through paragraph 1. I'll touch briefly on this, but assume it's going to be an issue that's hotly reviewed by our expert and will be hotly challenged in cross-examination at the appropriate moment. There is, of course, an MFN clause in this treaty. We understand that clause to be broad, and pursuant to our expert, we believe that as an alternative argument, that MFN clause can be utilized to support, number one, our theory, and number two, consent if necessary. Which leads us to the jurisdictional objection, and leads us to what is being argued by the respondent. We contend that the jurisdictional objection is not supported by a fair, good faith reading of the text of the treaty. It's not supported by the preparatory works. It's not supported by investment arbitration decisions, which we've reviewed and the tribunal has now seen again. Is not supported by the authorities relied upon by the state. It's not. It's not supported by the treaty's lead negotiator. It's not supported by the Dominican lead negotiator. It's not supported by reference to other BITs, not supported by any expert, not supported by any fact witness. The jurisdictional defense was an afterthought. It's not what the Dominican Republic, we contend, believed to be the right action to take. We believe the Dominican Republic knew that they consented to arbitration. They acted as though UNCITRAL was unequivocally the rules that were going to bind the arbitral process. The opportunity presented itself to raise a consent jurisdictional defense. They leaped at that opportunity. And the goal is clear. Number one, to delay. And number two, to avoid the economic consequence of what is a clear expropriation, under the hope that this arbitration will die here so that they can compel Mr. Lee Chin to take action somewhere. Where? Time will tell. That can't be the outcome of this case. We believe that they've consented to jurisdiction. We believe that the treaty covers indirect investment. And we believe that this case should promptly and expeditiously move to the merits. Mr. Chairman, members of the tribunal, colleagues, and of course, representatives from the Dominican Republic, I thank you for your time, and I'm available to the extent possible to address any questions the tribunal may have. Thank you, sir.
Thank you. Thank you. Before time, it is 40 minutes.
Clement has used 1 hour and 40 minutes.
Thank you. So you have a bonus of 20 minutes for the future. You may use, not shall. Okay. Any question?
I just have one question on your relief sword.
Oh, yes.
You say both in your two submissions on jurisdiction, the declaration summarily dismissing the state's jurisdictional challenge. Should we read anything into summarily?
Fast?
Thank you.
Well, vamos a hacer un pequeño break.
Let's take a small 10-minute break to call the witness and begin his interrogation. Thank you.